anything to do before the Honorable, the Justices of the Appeals Court, now sitting at Boston within and for the Commonwealth. Draw near, give your attendance, and you shall be heard. God save the Commonwealth of Massachusetts. This court is open. Please be seated.
Good morning, everyone, and welcome to the Appeals Court. My name is Amy Blake. To my right is Justice Maureen Walsh. To my left is Justice Christopher Hodgens. We are your panel for the 5 cases that are before the court today. Just by way of a brief introduction, each side, except for those cases that we've changed their scheduling on this morning, are permitted 15 minutes of argument. There is no rebuttal. We ask that you get right to your arguments as we have read all of your materials. And with that, we're going to call the first 2 cases, which are paired cases. They are docket numbers 23P1269 and 23P1270, Michael Hutchinson versus Eric Gillis and another, and Laura Jute versus Eric Gillis and another. Counsel, when you're ready.
Good morning.
If you could come to the microphone, please.
All right. Good morning, Honorable Justices. I am Attorney Sydney Sheeran here for Ms. Jute and Mr. Hutchinson. So there are 2 main points that I want to touch here today. The first being that the Hampden County Superior Court abused its discretion when it denied both Ms. Jute and Mr. Hutchinson's complaint on grounds of untimeliness. So the complaints were dismissed on grounds of untimeliness for being filed with the Hampden County Superior Court 1 day after the 60-day statute of limitations had expired. However, Mr. Hutchinson and Ms. Jute both deserve the presumption from the court that the Hampden County Court's office did indeed receive their complaints on or before the deadline, but however that they were filed after the deadline. And to support—
What does the rule say?
The rule says that
They must be sent by certified mail in order to be deemed filed, and yours were not. Yours were sent by U.S. mail.
Okay, then my apologies. But to support my—
To start a complaint, you can file something by mail, but it has to be by certified mail.
By mail.
And so you did not. So whether it's a day or 100 days, it's late.
Okay.
So maybe you should move to the substance of your argument on unsuitability.
Well, my second argument is to address the issues that the Hampden County Superior Court abused its discretion when it affirmed the district court's denial of both Ms. Jute and Mr. Hutchinson's LTC application. In the role of the appellate court, as you know, is to examine the record of the district court and to correct any substantial errors of law that they may have, or that may have been made that assertedly affect someone's material rights. So starting with Ms. Jute, focusing on her case alone, she did not do anything, or she has nothing in her record that would deem her unsuitable, as the decision from the Westfield District Court was, in fact, arbitrary and capricious, and the Hampden County Superior Court did, in fact, abuse its discretion when it decided to uphold it. Chief Gillis—
Let me ask you this, though. You would agree that you don't have to have a conviction for the chief to consider her criminal history, right?
Agreed, yes.
So it seems that there has been, I'm going to use the word tumultuous relationship between your clients.
Yes.
Sometimes, at least on the police reports, perhaps he was the aggressor, sometimes she was the aggressor, sometimes it seems that they were perhaps mutually aggressive to one another and neighbors were calling the police. You're not suggesting that the chief can't consider that, right?
No, I know the chief can consider it. I'm more suggesting that had further inquiry into the facts been considered, that the chief would have found that there was never any physicality between the two, and yes—
Even if that's true, right? That whatever domestic disputes they had did not rise to the level of a physical assault. Again, isn't it within the chief's discretion to consider each of them to be unsuitable based on the tumultuous I'm using that word in particular as opposed to a violent relationship, tumultuous relationship.
No, I do believe that it is in their discretion to definitely take that into consideration when they're deciding if someone is suitable or unsuitable.
And what would the investigation have shown? She would have said, no problem, we have a great relationship. He would have said, no problem, we have a great relationship, because that's basically what they both testified to in the district court.
No, that is true, but they both did
Judge
admit.
didn't believe him.
I know, but they both did admit that, yes, they had fought on multiple occasions verbally, but just because a couple is fighting loudly, I don't think that should rise to the level of deeming someone unsuitable to possess an LTC, where they both admitted multiple times and on these occasions that there was disputes. However, they both also admitted they never got physical between each other, and they both separated each other on multiple instances.
So can I ask you this, as to her, Ms.
Yeah.
Jute, what case do we have that is factually similar to your case? He's in a different position, right? He has a lot more
Yeah, he has a lot
involvement.
more, yes.
What do we have that's closest to her factual situation where a decision to not grant a license to carry was reversed? What's your best case?
Well, I would say that you could reference, well, in regards to her with the Section 12, the case that, or at least in the statute that says that you have to be committed to, or if you are committed for mental health, that you're statutorily prohibited. At least in the case when she did her welfare check, there has been cases that if you're not actually committed, then you wouldn't be statutorily deemed disqualified from it.
I don't think there was a statutory disqualification here, right? This was a
No, yes, there
judgment call
wasn't.
of the chief. I'm just trying to figure out if we have any cases where your argument has been successful and the facts are at least close to or akin to those presented by Ms. Jute.
I don't think there's a case that's pinpoint with the same circumstances.
Okay.
Am I good to move on?
It's your time.
All right, so regarding Ms. Jute, like I said, that she was Section 12 at one point, and this was something that was referenced by Chief Gillis in the reasons for deeming her unsuitable. This was a welfare check that was actually done by a third party that had limited information. At the time, as you know, Ms. Jute was home with her mother.
Interrupt just for a moment.
Yep.
Because we have read the record, and I think we are aware of the
Familiar with
facts.
everything.
And I appreciate that. I just want to make sure that I'm clear, and that's because you've cited arbitrary and capricious, abuse of discretion, and substantial error of law.
Mm-hmm.
So explain to me exactly where the district court judge erred and where the Superior Court judge in affirming that decision.
That decision.
Yeah. Tell me where they got it wrong.
So I believe that the district court judge erred when they did not deem the licensing authority's decision arbitrary and capricious, because based on the facts, if there had been further inquiry into them, it would have been shown that there is not reliable and substantial evidence to deem Ms. Jute unsuitable, because looking at all the facts and circumstances of the cases that were cited, or of the incidents that were cited by Chief Gillis, there's not a direct correlation or nexus between her behavior and her actions and a risk to public safety if she was given an LTC. So that's where I believe that the district court's decision was arbitrary, where the district court erred because the decision was arbitrary and capricious by the licensing authority. And then,
Let me just make sure I understand. Even if the chief has the discretion and to decide, I believe this over that, right?
Yep.
So you agree the
Yes.
chief can make those findings? And even if the chief believes that the two were involved in a tumultuous relationship, and for Ms. Jute in particular, she did have at least an episode which resulted in a well-being check, right? And so I guess my question to you is it because there's no connection to the harm or risk in carrying a license to carry? Because I don't see how that could be true. If somebody is involved in a tumultuous relationship or has some instabilities, I would imagine that the case law would support the chief's discretion to deny in those instances. But tell me what...
So the chief does have immense discretion. I'm not doubting that. And these are definitely things that they're going to take into consideration. But I don't believe that their discretion should go as far as being able to deny someone of their right to have their LTC for an argument or for being evaluated but was released 2 hours later and deemed not a threat. Like, I believe that their actions and everything should be taken into account just as much as the fact that the cops were called, the cops showed up. I think the surrounding circumstances of what their exact behavior was, what the exact circumstances were, should also be taken into consideration when the judge is using its when the licensing authority is using its discretion to determine if they are suitable or unsuitable. And in my opinion, it seems like the licensing authority only focused on the fact that the cops were called or that she was required to be evaluated at the hospital under Section 12 and didn't look further into the circumstances surrounding it.
You know, you did a very good job of putting this together, but I'm just wondering if sometimes, the facts just really aren't there. Because one thing that stood out to me was, although, this JUTTE's history is minimal, certainly, but what stands out, though, is, like, for example, 11/5/17 is a domestic in progress, and the police respond to that. That's at 1:40 a.m. And that stood out to me, and I just wonder if that's something that might have stood out to the chief, too, because if you had people armed in that residence during a domestic at 1:40 a.m. and the police are responding, domestic cases are very dangerous to begin with when police respond, but now at 1:40 a.m. with people armed, isn't that an elevated risk to public safety? I mean, aren't the police part of the public that we're trying to protect?
I mean, I do believe that, yes, that is an escalated situation at 1 a.m., especially if other people, like neighbors, had heard them fighting, in which would lead to someone calling the officers. However, you can't reasonably assume that just because they were fighting just because they were fighting and if they had an just because they were fighting and if they had an LTC, that it would rise to the level of violence, because there's no showing violence between the two couples. When the officers arrived for that scene, they both admitted to fighting and they both also admitted that there was no physical harm. So to assume that if they had an LTC, they would automatically misuse it just because the couple fights, I don't think is fair if they don't have a history of showing physical violence, considering also how many people argue all the time. And yes, I do think it is of concern that this call happened that late, and obviously for someone else to call the cops, they must have heard them. But I do think as the facts are presented, it should be noted that there was no physicality, and just because they are fighting and they are a couple that argues loudly, if they were given an LTC, we shouldn't assume that they're automatically going to incorrectly use it and cause a risk to safety if they have no history justifying that.
As an attorney, you have a little more difficult reach for Mr. Hutchinson, would you
Yes,
agree?
yep, I would agree with that.
So do your best in advocating and telling us why
For Mr. Hutchinson, there was a few ROs that were mentioned in the denial letter, of course. I will argue, though, that one of them resulted in an assault and battery charge, and another incident resulted in an assault and battery charge with him and the other party. However, both of these situations actually were him acting in self-defense. As you know, one of them was heard in front of a jury and he was found not guilty for reasons of self-defense. And the other one, both parties admitted to hitting and being physical with each other, and they were both ended up being charged with that one as well.
To
So help me with the road rage incident.
The road rage incident, I would argue that, yes, he did show some inappropriate behavior with acting the way he did, but he was under a pressured situation where a car did hit him and he wanted,
Allegedly.
allegedly hit him, and he wanted to get their information to be able to resolve it. I mean, yes.
It's an interesting approach to getting information.
I agree with that. I do agree with that, but it also did not rise, again, to any physicality between the two parties, and he does allege or admit or state that the other party was trying to flee the scene. And given those circumstances, after you just get in some type of altercation in the car, it definitely was a situation where emotions were running high, and I think that, yes, he did not act appropriately, and there's a lot better ways he could have handled it. However, even in a situation that is so high-pressured and high-tempered and someone's upset, he still didn't rise to the level of physical violence or with the
I'll tell you,
victim.
reading the exhibits that came in the district court below for Mr. Hutchison, it struck me that and he has had numerous contacts with law enforcement for an extended period of time. Every single contact, he blames everyone but himself. He takes absolutely no responsibility for any of his actions, even if, to your point, there is some degree of mutual combat in these domestic relationships. 2 restraining orders, 2 different women, I think police reports from 9 different police departments. He just doesn't take any responsibility. And every time I read about the road rage incident, I thought, yep, and if he had a gun, that would have come out.
But can you arguably assume that it's going to come out? If he's never...
Isn't the chief trying to prevent that gun from coming out?
Yes, and the chief does have that right to prevent any further risk on society or anybody's safety, but it's also unfair to presume that he is automatically going to be a risk to safety when, yes, he has a long history, we'll say.
Well, the statute refers to a risk, right?
Yes.
It's not a certainty.
But the statute also requires credible and reliable evidence that they would be a risk to public safety.
Well, let me ask you about that, because you said in both cases that the police should have done something more, the chief should have done something more, and as I read it, it looked like he did a pretty thorough job of combing the records of both individuals and, put it all together in a pretty concise letter. I'm not sure what more he could do. Isn't he entitled to rely upon police reports from various jurisdictions where I did notice that invariably the police did obtain statements from your clients at the time, back in 2002, 2004, 2010. Are you suggesting that he should reinvestigate those matters and get new statements from them?
No, but I am suggesting that at least a cursory interview with either Ms. Ju or Mr. Hutchison before the denial letter, or even asking a few questions to the witnesses or the alleged victims just to get the full story. And I know any police report, or I know the licensing authority has complete authority and power to rely on the police reports to make their determination, but I don't think a police report should always be given 100% credibility, not saying that they're not credible, but there are some times where there isn't the full story or the full circumstances listed in it. And I think that when dealing with something such as someone's right to have an LTC or right to have a firearm, it should be on the licensing authority to conduct some further investigation besides just looking at the report, such as a simple cursory interview or interview with the witnesses, or just even a few questions asking about the situation. All right. And then, so also with Mr. Hutchison, as you know, the other incident that involved Ms. Jute as well. And that one was also one that there had not been any physicality in it as well. So I do know that Mr. Hutchinson has a long record. There's no denying that. But I will say that 2 of the altercations, he was acting in self-defense. And yes, there may be a history of him not taking responsibility for things, but also for cases that have been dismissed or where he was found not guilty, he does deserve the right to be presumed innocent because he was not found guilty or they were dismissed. And so with that being said, I believe that for the reasons as stated, I believe that the district court erred when they decided to affirm the LTC denial of both Ms. Jute and Mr. Hutchinson because the decision was in fact arbitrary and capricious. And with that being said, that there was no credible, reliable evidence that would show or exemplify that they would be a risk to public safety given the LTC, as there is no history of physicality with Ms. Jute, and the situations with Mr. Hutchinson, he should not be denied his LTC based on his right to a self-defense. So with that being said, I would suggest, or no, with that being said, the Superior Court of Hampton County, I would say abused its discretion when it affirmed the district court's denial or decision to uphold the denial. And I would request that this honorable court reverse and vacate both Ms. Jute and Mr. Hutchinson's denial of their LTC.
Thank you very much.
Thank you.
Counsel, when you're ready.
Good morning. May it please the court?
Good morning.
John Fitzgerald on behalf of the town of Agawam and Chief Eric Gillis, Police Chief of Agawam. So I would suggest to the court that this system worked properly. It worked as it's designed. It worked as the law demands that it does. The chief, after gathering evidence, which included police narratives, police reports, as pointed out by multiple police departments, not totem pole hearsay, but actual witnesses, made a determination that both parties were unsuitable. He has considerable latitude in that decision.
You would agree, though, that Hutchinson's case is probably a little clearer cut than Jute's.
After having done these hearings at the district court level for 4 different municipalities and having sat in the district court for 2 decades hearing them, yes, I would certainly say that Mr. Hutchinson's contact with law enforcement is more significant than Ms. Jute's.
So can you summarize for me sort of what your view is as to what puts Jute's over the top?
Well, in at least one of the police narratives, I note that she refused to let Mr. Hutchinson leave, physically assaulting him, scratching him. And those are, I believe, his words to the police. Now, why it didn't proceed at the criminal level in district court, I can speculate. I don't honestly know. But I've seen it happen more often than not where a case like that doesn't proceed. In terms of responding to Ms. Jute, what is most disturbing to me, beyond that physical altercation, the other contacts with law enforcement, it's the mental health aspect. Maybe 2 hours later, after she was brought to Bay State Medical Center in Springfield, she wasn't a threat any longer. But at that time, she was threatening suicide. At that time, she ran from the police and tried to lock herself in the house. They had to forcibly remove her, forcibly take her by ambulance. I think the chief took that into consideration, along with the other aspects of her case, when he decided she wasn't a suitable person. That's his prerogative to do that. It's his under the law to do that. The review takes place at the district court, as you're aware. Charles Gross, Judge Gross, I think he's been sitting for about 10 years. He's heard probably thousands of these appeal cases. He decided, taking all the evidence...
Thousands might be about 900 overestimate, but go ahead.
I'm sorry, Judge Walsh?
I said thousands might be about 900 overestimating it, but continue.
I've tried at least, at least 15 in front of Judge Gross, so I assume he's hearing a lot more than that.
All right, we have 985, but we only have 12 minutes on the clock, so I'll let that one slide.
Thank you, Judge. Excuse my hyperbole. He's heard a few, and he's been on the bench a while. He heard the evidence. He heard the appeal. He factored that in, and he decided that there was no abuse of discretion on behalf of the chief. It goes to Superior Court. Although tardy, although late, I won't really get into that other than to share a quick story that I was thinking of on my way in. When I was a young law clerk, about 22 years old, I worked for a very small firm in Springfield, Keyes and Donlin. And Judge Donlin, I'm sorry, it was Judge Keyes. It was Mr. Donlin said to me once, he goes, "John, don't ever forget, if you're not early, you're late." And that's what I was thinking of as I was driving down the turnpike at 6 this morning, trying to make sure that I was very early for this hearing, because we all know how important statutes are, and we need to follow them. And they were not followed in this case. And I would note that they were on a similar filing earlier in the case. That was actually referenced in the appellant's brief, and they used that as evidence that there was somehow this mysterious letter disappearing for a series of days before it's stamped into the clerk's office. But that aside, the main argument that I would like the court to hear from me today is that the system worked exactly like it was supposed to. In fact, I would suggest to the court that the Superior Court really didn't even need to hear anything about the second prong of this, which is whether there was a substantial error of law committed at the district court level. They chose to, but they really didn't need to, because the first prong was whether it was properly dismissed for timeliness. They ruled that it was. I believe that was proper, and I don't believe there's any other reason to go forward beyond that analysis.
What do you say about the argument that something more is required in terms of maybe some sort of a face-to-face meeting with the chief, that this shouldn't be decided on the papers, that applicants should have a chance to kind of make their case in front of the chief? What are your thoughts on that?
I don't agree with that, and here's why. It would stop the system dead in its tracks with what we have. But beyond that, and that's just a matter-of-fact analysis of it. But the appeal is to the district court, a neutral party, a neutral judge. He gets to hear. The appellants have their opportunity to make their arguments why Chief Gillis was wrong in what he decided, why he was wrong in deciding that the mental health threat to kill oneself mattered, why the contacts with law enforcement mattered. He heard that evidence. He alone heard that evidence. It was the district court's purview to do that, and I don't think it's appropriate. In the 4 municipalities where I've worked, no police chief has ever done that before that I'm aware of. And I can't speak for other towns, but the 4, and 3 of them were fairly large for Western Mass standards. They don't do that. They just go by the records that they have. And they don't just go by the quarry, and that's important. That's a distinction too. They actually go through their system and they see what contact they've had.
It doesn't appear that the panel has any other questions. We're happy to take the rest of your argument on your brief if you'd like.
I would like that. Thank you very much.
Case will have been deemed submitted. Thank you, counsel, both. Thank you. Our next case is 23P1271, SUSANNAH Kay and another versus the Town of Concord. Before council gets started, just so that the lawyers are aware, the panel has received and reviewed the materials in camera. You may proceed.
Good morning. May it please the court, my name is Robert Nislik, and I am counsel to the appellants SUSANNAH Kay and Brooks Reed. This appeal presents a question of whether public records, which are email communications primarily between and among select board members, which were not between an attorney and a client, where none of the requirements under the open meeting law for entering into executive session can be attorney-client privileged in any event. The appellants contend that in this appeal, in which the members of the Concord Select Board primarily communicated between and among themselves, along with their town manager, and in one of the cases, it was two employees of the town communicating with each other from the Public Works Department, where no attorney was copied on any of these emails. There were 14 of them that, per se, there's nothing that permits this court to find that those communications can be privileged. This case was submitted as a motion for summary judgment. Both parties moved for summary judgment. There were really no facts that were contested. All of the facts were the 14 emails, and in all of the emails at issue, we contended and the town agreed that none of them were attorney-client privileged.
But can I ask you a broader question, which is, what is really going on here? This case cannot be about 14 emails.
The case, in large part, is about transparency in government. My clients...
So let's say you get all the emails, then what?
Well, we'll review the emails, and it's likely that, or it's possible that my clients will be satisfied that that their rights under the public records law and the open meeting law were satisfied. I think the reason why...
And if they're not?
Well...
What's the cause of action? What's looming out there?
Well, what's looming out there is the fact that my clients were sued by the town of Concord in a case that was litigated in the land court to establish that a 2-mile-long trail was a public way. During the course of discovery in that case, the town produced redacted versions of several emails that, upon our review of those emails, we determined that they were open meeting law violations. My clients
And the AG agreed with you in part?
The AG agreed with us in part and ordered the town to release the emails. In some, I think there were 4 specific ones because they were based upon deliberations.
Is the land court litigation concluded?
The land court litigation is under advisement.
In this court?
Yes. I mean, I think Your Honor was on.
I was on the panel. How does this case impact that case, if at all?
Well, this case is a different cause of action. This case is whether our clients have the right under the public records law to obtain unredacted versions of public records that are undisputed to be public. You know, after my clients were sued without any notice whatsoever, they naturally became skeptical of how the town was making decisions and were reasonably upset about it.
All right, so you get the emails and you determine that there wasn't transparency in government. What's the remedy? What are your clients looking for?
My clients are looking for the release of the unredacted versions of the emails.
Okay, so hypothetically, we give those to you. Then what? I'm trying to figure out where this case fits into the grand scheme of things. I feel like there's something we don't know.
Well, I think my clients feel that there's something that they don't know either. And they don't understand how they were sued without notice. I mean, we're looking at emails that date back to 2016, 2 years before litigation in the land court was filed against them. If the town was contemplating filing a lawsuit as a plaintiff against people who were essentially private, not particularly involved citizens in the town. Presumably, if the town was doing its job, the fact that they were contemplating filing a lawsuit against my clients and other landowners would have been noticed. It would have been on an agenda. If the town needed to communicate to preserve their litigation strategy, they had the ability under the open meeting law, under 3821B, to basically say, look, we need to go into executive session to decide whether we want to file a lawsuit against various town members. Well, none of that happened.
Can I interrupt for a
Sure.
moment? Anything that's decided in this case, whether you get all the emails, some of the emails, or none of the emails, does it have any impact as to whether Estabrook Road is a public or a private way?
Probably not. Okay. I think but this is.
And I can appreciate your position of transparency in government, okay? So I'm not downplaying that. I just want to see where this is connected, like my colleague, and where it isn't. So if probably not, then what we're talking about is 14 emails that you believe, as a result of especially the letter of the Attorney General's office, that you should get full unredacted copies. And it's difficult for you as an attorney, right? Because you don't know what's in there to make an argument that it isn't protected by the attorney-client privilege. I mean, that's a tough position to have to advocate when you don't know what's inside there. On the other hand, when I look at your arguments, your legal arguments, I appreciate the fact that you recognize, and correct me at any time that when I'm wrong, you recognize that an attorney-client privilege does exist, that whenever an attorney from the town of Concord is speaking to a select person or the town manager, correct, that this does apply, and that you're not seeking any lawyer email or talk to his or her clients. It's bilateral, right? It's when select people talk to one another about whatever the lawyer may or may not have said. The problem that I have with your argument is that it doesn't appear to be supported by the case law. So I read Suffolk Construction, which ironically has to do with this very building and satisfaction or lack thereof of people believing that the building was properly renovated, as saying, certainly, that important question of public records and open meeting applies to municipalities, right? And this is, I understand yours is that second rung. It's when people, but the only way in which the clients, the select board members and the town manager communicate, right, is through the attorney. So if the attorney says to one of its clients, here's my legal opinion, and that legal opinion is then forwarded to, just play out with this one, to the other select people, would you agree or disagree that attorney-client privilege applies?
I would disagree that attorney-client privilege applies.
Tell me why.
Well, first of all, these were communications in none of them were between an attorney and a client. They were all communicating with each other.
Right. But in my, I had the different hypothetical. Lawyer, clients, sends to one client a legal opinion, and I forward it to my clients, to my colleagues. Attorney-client privilege, this way?
I am not aware that there's been any case that adopts the ability of select board members to do that. I mean, it happens
In corporations where the corporation doesn't live and breathe. In that the individuals, right?
Your Honor, I would rely primarily on the Middleborough case, which
So you disagree that whenever, I just want to make sure I understand, you disagree that A, is it the municipality factor, or B, that in just, take it out of the select board, right? Because this is this case. In a corporation, your corporate counsel now, and you give one of the partners some legal advice about something, and partners pass it along to the other big shots that all have hired you. Does it go this way?
Your Honor, respectfully, I would say, and this is even from a provision that I quoted in the restatement of the law governing lawyers, that a different provision applies in government. And I cited.
Suffolk says it doesn't. Suffolk says government's entitled to the same type of protection.
My understanding, Your Honor, is that Suffolk construction states a general proposition that the attorney-client privilege exists. It presupposes that attorney-client communications have occurred. I think what we have here is a situation where appellate case law, particularly the Middleborough case, states that the open meeting law is a statutory public waiver of any possible privilege of the public client in meetings of governmental bodies, except in the narrow circumstances stated in the statute. So I think that the Middleborough case is the primarily controlling case, and it overcomes any general proposition that may be stated in Suffolk construction that the attorney-client privilege exists generally. I think one of the problems relying on Suffolk construction is that it does not hold that non-attorney-client communications are privileged. I think that there was no issue in Suffolk construction, no factual issue dealing with non-attorney-client communications. I think the problem that the court below made is that they cited the general proposition of Suffolk construction as some kind of blanket or umbrella, and the judge ran with it to basically say, I don't care that these were non-attorney-client communications.
But you don't agree with the proposition that an attorney can represent multiple clients, and the conversation between and amongst the clients about that attorney's representation, your position is not protected by attorney-client privilege, if I understand it exactly.
Well, I think that the question you're asking me is basically whether I think America's Test Kitchen is good law, and that involves a corporate application of the attorney-client privilege. This is not a corporate application of the privilege. It's a governmental question of whether the privilege applies, and appellate case law states clearly that the open meeting law is a statutory public waiver of privilege. There's nothing that I've seen that actually counters that.
I just want to make sure that I completely understand. If you're saying that I'm mischaracterizing your legal argument, I honestly want to hear it, because that's what I understand it. I read Test Kitchen, I read Suffolk Construction, and reading your brief, and it's excellent, by the way, it's that you don't believe attorney-client privilege flows in between in a municipality such as select boards when they speak about potentially legal opinions.
I think that's accurate, Your Honor, and our understanding is that when a select board wants to discuss litigation or wants to discuss the advice of counsel, there's a very, very specific mechanism in the open meeting law that allows them to do that, none of which was followed in any of these emails. These were essentially deliberations between attorneys, between select board members, where their attorneys were not copied on it. I think if...
So I'm going to have to ask you to wrap it up.
To wrap it up. Okay, well, essentially this is a case where none of the emails were privileged. appellate case law, Middleborough, demonstrates that the open meeting law is a public waiver. Suffolk construction is a general proposition, not applicable to this case in particular. And the court did not rely on any appellate case law which establishes that select board members can communicate confidentially with each other without their attorney unless they abide by the strictures of the open meeting law.
Thank you very much.
Thank you very much.
Mr. Paganelli?
Good morning, Your Honors. Austin Anderson for the Town of Concord. So the emails that we're talking about here are covered by the classic formulation of the attorney-client privilege. This is the Commissioner of Revenue case that the appellants actually cite in their
Actually, it's really not the attorney-client privilege. It's the derivative attorney-client privilege that you're invoking. Isn't that right?
So the way the SJC formulates this, if where a client is making a request of legal advice from counsel, all communications relating to that purpose are covered by the privilege. As Justice Walsh recognized, when a client is an organization, those communications necessarily have to take place among the employees and agents of the organization.
Only for the purpose of obtaining legal advice. The advice here was already rendered when these conversations took place.
Respectfully, Your Honor, it's for the purpose of seeking or obtaining legal advice. The
legal advice was given, and then the select board members started to discuss it, right?
There are 14 different emails in the record. Some of them follow that pattern. Other ones are discussions from select board members to the town manager saying, we should ask legal counsel for advice about X. That is a communication relevant to seeking legal advice from counsel. So the ones that you're referring to are exactly the same as Justice Walsh's hypothetical, which is not a hypothetical in this case. There's an email from town council to the town manager giving legal advice, stating a legal opinion, and then the town manager forwards it to the select board members and says, here's what town council is saying. The select board are the ones who need to understand and implement this legal advice. That needs to be protected in order for a...
What? Who says?
If the town risks a waiver of the privilege anytime there's an internal communication to implement legal advice, then public entities would be at a serious disadvantage compared to corporations and private entities, which is exactly what Suffolk Construction says you cannot have. The normal rules of the privilege apply. So their options would be either you need to pay an attorney to sit in on every conversation and be copied on every email, or you risk waiving the privilege, and in a public records request, your adversary in litigation has access to...
You don't exchange emails and you go into executive session and you follow the procedures for going into executive session, and you do it that way.
So this is an important point. The open meeting law only applies to discussions among a quorum of the select board. It does not apply to the town manager, and it does not apply to conversations between the town manager and less than a full quorum. 4 of the emails here were improper deliberations. The AG addressed that, by the way, was asked to release unredacted copies of the emails and specifically declined to do so because it recognized that a violation of the open meeting law is not an automatic waiver of the privilege. But the remaining emails we're talking about, the OML has no application whatsoever. The town manager is allowed to talk to 1 or 2 members of the select board or anybody else in town without following the requirements of the open meeting law. So there's no statutory waiver, there's no problem.
Town manager's not acting as an attorney, though.
The town manager has the authority under the town charter to direct the town's legal services. So the town manager is the point of contact for town council.
Yeah, but okay, the Supreme Judicial Court has told us that the privilege is narrowly construed. Narrowly, strictly construed. You seem to be trying to broadly construe it. That, well, you're not an attorney, but the attorney-client privilege will apply.
Respectfully, Your Honor, we're not trying to expand the scope of the privilege. These communications, if they were between a client and an attorney, I don't think there's any question at all that they would be privileged. They are requests for or communications seeking or receiving legal advice. This is at the very heart of the privilege. So the only question is whether, when you have an organizational client that has to act through its employees and agents, whether those employees and agents are able to talk about the requests for and receipt of legal advice without waiving the privilege, or if they need to have an attorney involved in every communication. The practical consequences of requiring an attorney to be involved in every communication would be disastrous for public entities all across the state. We're not just talking about towns here, although the financial consequences would be particularly dire for towns. The MBTA, Massport, the UMass system, they would have to fundamentally redo the way that they currently...
No, but I think you're overstating that quite a bit. I mean, why can't the town manager just call one member of the Board of Selectmen and say, hey, we got this opinion, I think it has some serious consequences for the town, we need to put this on the agenda, what do you say? Yeah, okay, let's put it on the agenda. It's put on the agenda. The chairman of the select board announces we're going to go into executive session because we want to discuss a legal opinion that we received regarding a matter that's pending litigation or anticipated litigation. All those in favor? Aye, aye, okay, we're in executive session. And then you can discuss it for as long as you want. In secret, you're all set.
Respectfully, Your Honor, that would be impractical in the context of ongoing litigation. We're not one piece of legal advice that the select board needs to talk about at length in session. The town is in constant communication with attorneys during litigation, is getting advice on aspects of litigation. The town manager is discussing strategy with the attorneys.
Okay, and that's all privileged, and that's fine. Right? I think your opposition agrees with that. So but that's not what's at issue here. What's at issue here is you receive an opinion, and then the select board members decide to discuss it among themselves in emails.
And because the
opinion has been rendered, so their discussions are not with an eye towards obtaining legal advice. They're just discussing, geez, what do we do with this opinion now? At fair game, you can discuss it in an executive session. The legislature has provided a vehicle for that. But if you carelessly discuss this in emails, that's not privileged.
Your Honor, I don't think there's anything careless about the discussions here because they are not subject to the open meeting law. You do not require a formal action of the board.
They're subject to the public record law.
But they are privileged and therefore not subject to the public records law under Suffolk. So you don't need a formal action of the board in order to receive and implement legal advice. If you needed a publicly noticed meeting with 2 days notice and all of that, every time the town manager needed to tell 1 or 2 select board members about legal advice they're receiving from counsel in the context of ongoing litigation, there would be meetings constantly. It would paralyze the town's ability to receive and act on legal advice.
Well, let me ask you this, because we have to apply what the Supreme Judicial Court has told us. And back in 1979, the court said this: the public has an interest in knowing whether public servants are carrying out their duties in an efficient and law-abiding manner. That's the nature of the public record law. So why is it that you have residents in town, they get wind of it, apparently they know there's some emails circulating, and they want to know what's in those emails, and does it have something to do with this litigation?
And
Why isn't that fair game?
So, Your Honor, I have no quarrel with the general principle of open government and transparency and governance, but Suffolk has already answered this question. Suffolk says if those emails are privileged, then the public does not get access to them. We cannot put public entities at a disadvantage vis-a-vis their private counterparts when it comes to the privilege. And it goes through a long discussion of all of the important policy reasons that that's the case. We want public entities to be able to seek legal advice from counsel so they can conform their actions to the law. And if adding these onerous requirements of a noticed meeting every time you need to discuss legal advice, including with less than a quorum of the board, again, the majority of the emails there's no application of the open meeting law at all, and there's no reason that you need a formal noticed meeting in order for the town manager to relay legal advice to the people who are responsible for understanding and implementing it. If the board wants to take a formal action based on that legal advice, it needs a noticed meeting, it will go into an executive session. That also happened in this case many times, but they did not need one every single time the town manager got an email from council that he wanted the select board to be aware of as they were directing his
Do you have a case that says the attorney-client privilege applies to select board members having a discussion? Because Suffolk doesn't say that, so there must be some other case out there that you're relying on, because I'm not aware of it.
So we're relying primarily on the principle, as articulated in America's Test Kitchen, Doe v. Leahy Health, in the Mass Guide to Evidence, that when you have an organization, communications among the employees about legal advice are covered by the privilege, in addition to Suffolk, which says the normal rules of the privilege apply to public entities. As far as I'm aware, this hasn't been litigated. We haven't cited a case saying exactly we want. They certainly haven't cited a case coming anywhere near the argument that they're making.
But you called the claim, you called your brother's claim frivolous, but it hasn't been litigated, but you're saying it's frivolous, and you're asking for attorney's fees and costs.
All of the cases and authority out there point in one direction, and that's that these communications are privileged. They have never had any valid authority suggesting otherwise. In fact, they've repeatedly relied on a provision of the Guide to Evidence that the SJC specifically rejected in Suffolk. The only thing they're citing is something that they know is invalid. I think that is strong evidence that their claim is frivolous.
Jumping to that issue, you realize that despite your opposition, that the court ordered the transfer of the unredacted emails, since it's a de novo review. And my first question is if we accept your analysis that select board and town members are afforded potentially an attorney-client privilege in these instances. Again, reminding you that we've read them all. You're standing your ground on all 14.
Each of the 14, well, there's one work product email that is treats differently, but
You're standing your ground on all 14.
we are, yes. They each come within the classic formulation of the privilege. And I understand, and the Superior Court informed the Reed case, that there's nothing particularly interesting about these documents, but they do all constitute discussions of requests for legal advice or discussions regarding legal advice received from counsel.
It's just difficult, I have to be honest with you. Hearing on one hand this belief in transparency and the importance of government to be able to have just a feeling, if you will, that what's going on is correct and right to this position. Even if legally correct of the analysis of attorney-client privilege, it's just interesting to hear both transparency, but you can't have it.
So, Your Honor, I have 2 points in response to that. The first is that when dealing with a town client, the individuals who sent and received these emails are no longer town manager and members of the select board. So if the people who serve in those positions know that a few years down the road, somebody else in their position is going to choose to waive their privilege because they think it's expedient to do so, there's going to be a chilling effect on the town's willingness and ability to receive legal advice. The second point is that we do not, respectfully, I think it would be a mistake to implement some sort of requirement of a judgment call as to how substantive or important these emails are. There's no support in the case law for that.
I'm not suggesting that perhaps you may be right. If an attorney writes an email to a client and says, hey, how about those Red Sox? Is that attorney-client privilege?
No.
Okay. If an attorney writes an email to a client and says, I think you should plead guilty, here are all the reasons, attorney-client privilege?
Yes.
Okay. An attorney writes an email to a client and says, please see attached. Is that privileged?
Depending on what's in the attachment
Not the
probably is
attachment.
privileged. Not
Just
the
the email.
Please see attached.
You're not going to like this answer, Your Honor.
You shouldn't have to think long and hard about that question, counsel. Thank you.
Probably not. I'm reluctant to say as a black line rule, because depending on the context and what else is in the email thread, there might be a clue about something? Probably not. But your hypothetical, the answer is probably not.
Please see attached. Here you go. That's another one.
No, if the communication is not communicating legal advice, then it's not privileged. But the emails we have here are discussing, I know that they are surface level, but they are
Fine.
discussing seeking and receiving legal advice, and that's within the heart of the privilege. If
Do
we
you
thought,
agree, let me ask you this, because your time's running low. Do you agree with Mr. Nislik that this result of this case will not impact the other case?
yes, I agree with that. But I think your question was a good one, and the answer is if we turn these emails over, we're going to get another public records request tomorrow asking for every other privileged document, and we'll face a waiver argument. And, there's, Justice Blake, you're aware of the history between these parties. There's no reason to think that this ends with these 14 emails. I know that after reading them, you might be wondering about why we chose to draw the line here, but the principle is important for the governance issue I said before, and also we know that this doesn't end if we turn these emails over. So
We're going to have to leave it there.
appreciate it, Your Honors. Thank you.
Counsel, thank you both. Excellent arguments. The case is under advisement. Mr. Spady, is everyone here on the next case?
Yes, Your Honor.
Okay, thank you. Goes to the town of Concord, back to Concord. Going back to Concord. The parties on the next case can set up. It's Robert M.A. NADEAU and another versus Nancy MADORE PRATT, 23P 1267. Mr. NADEAU?
Thank you, Your Honor. Members of the panel, may it please the court, I'm Robert NADEAU, the appellant in this matter. This case, I appreciate Your Honor's explanations in the prior hearings, which I'm assuming also applies here, that you've all read the briefs.
We've read
and
everything.
the
You have
documents.
15 minutes, and there is no rebuttal. That is correct.
Right, thanks very much. That will save time. As the court is aware, this matter relates to a Uniform Foreign Depositions Act complaint that I filed in support of litigation in the state of Maine. The the complaint was supported by the orders of the Superior Court Justice in the Maine litigation, Justice Walker, and who issued orders urging the justices of this court and of two other state courts to order persons within their respective jurisdictions to comply with brief depositions in support of or in connection with the Maine litigation. He found that, based on the evidence submitted to him, that these particular witnesses possessed information that was discoverable under the discovery rules, which are very, very similar between Maine and Massachusetts, that they possessed information that was either relevant or likely to lead to the discovery of relevant information pertinent to the Maine litigation. So I filed this complaint under the Massachusetts version of that act here in the Essex Superior Court. And the action was dismissed sua sponte by a judge of that court. And
Can I just try to steer this towards what I think is the central issue in this case, as far as I can see? And I think you put your finger on it on page 42 of your brief, because you referred to the incongruity between the judge's decision here as far as your denying your request for the deposition in Mass Rule Civil Procedure 26. And that caught my eye.
Right.
more than anything else that's in here, and there's a lot of material in here, but that really stood out because I think as you were just about to lead up to, before I interrupted, what you requested was really a ministerial act by the judge.
Right.
It didn't really require a lot of digging into the facts and the background and so forth. So neither party, as I could see, cited this case, but I thought this was very significant. Maybe you can elaborate on this, because I think this is, it looks like this is what you were referring to. And the case is Alphys versus Kilduff, K-I-L-D-U-F-F, an appeals court decision from 2008, written by Justice Katzmann. And he's speaking about, or writing about, abusive process claims. And he says this: "We also note that traditionally discovery activities have not provided grounds for abuse of process actions in Massachusetts. We see no reason to extend a cause of action for abuse of process to the discovery practices complained of here. As a matter of policy, we agree with the judge that the abuse of process claim aimed at curtailing discovery activities would be inconsistent with the spirit of Mass Rule Civil Procedure 26B1, which affords broad latitude in the discovery of relevant information and is not limited to the issues raised in the pleadings or to the merits of the case." That struck me as exactly what's happened in this case, that you were seeking discovery, which is usually a broad right that parties have, and courts generally don't get too deeply involved in that in the early stages of the case, and that was short-circuited. So if you could focus on that, I think that would be helpful, at least to me.
Thank you very much for making those observations, Your Honor. You know, as you all know, I've been an attorney for a long time. I've been a jurist as well. It really more than puzzled me to see that something this simple and that focused and limited would not be accommodated, particularly where a main jurist had already evaluated the discoverability issues and had urged the court to cooperate, and he issued letters interrogatories, you know, as well. And what further corroborates the oddness of this circumstance is that because the justice in the Essex court not only denied me the opportunity to take what was represented on the record was going to be a 90-minute or less deposition of the defendant, in that case the appellee here, who became the counterclaimant because she had answered with a counterclaim premised on the fact that I filed this complaint asking for this authority. What's telling is on page 257 of the transcript, where we get to trial on the counterclaim 2 years later after my simple request to take her deposition was denied. I would have been happy to do right in front of the judge if she was really concerned about something inappropriate or harassing, but that was not offered.
Which volume of the transcript was 257?
I'm thinking, Your Honor, that that's in volume 2.
Okay, thank you.
And basically, what we're looking at is the special verdict questions on the trial, the counterclaim trial, the abusive process trial. The very first question presented to the jury was, did Mr. NADEAU use legal process in this case on and after April 10, 2017? Now, as the court is aware, that date of April 10, 2017 was the day that I filed the foreign deposition complaint, simply seeking authority to take a deposition in support of the main litigation. So the case law, from my experience and my view, and I've done a little more research on this, getting ready for this, does not support going forward, did not support going forward on the counterclaim, but the court denied my Rule 12b-6 motion to dismiss it. So there I was, stuck for the next 2 years, having to litigate, and this is the jury instruction that the jury was asked to vote on at the conclusion of the counterclaim trial. Did he use legal process in this case on and after, basically when the complaint was filed? All I had done, as you've seen in the record, from April 10, 2017 until she dismissed my complaint in November of that same year, was ask for a 90-minute deposition under whatever circumstances, whatever reasonable circumstances she deemed proper. You know, as you probably also noticed, after she denied that, I filed a motion for reconsideration. And I pointed out that this deposition was intended to be very limited and under circumstances that the judge would feel comfortable with. Ms. MADORE was never sworn under oath. There was no even at the hearing, it was basically a non-evidentiary hearing. And the judge denied my motion for reconsideration, and as I'm sure you've seen, she asserted in support of her denial that she had offered to...
Yes, this is at volume 1, I think it is, page 211, denied the motion for reconsideration and said that you had declined the court's offer for a shorter deposition. I didn't see that in the record. Did you decline the offer for a shorter deposition?
I did not, and as a matter of fact, the transcript of the hearing, Your Honor, transcript volume 1, pages 25 and 26, is quite contrary to her recollection, which of course was expressed in her denial of the reconsideration motion a few months after we had had the colloquy, the brief hearing. What happened in that hearing is the judge jumped to Ms. MADORE's defense by telling me, quote, you can't depose her, unquote, because it would somehow require her, quote, to incriminate herself, unquote. Well, in my experience, if a Fifth Amendment defense is to be applied with reference to a civil matter, and this was a civil matter, and not a criminal matter in the state of Maine, then certainly she has the right to assert the Fifth, but the court in a civil matter is free to then put whatever weight it might deem appropriate on that assertion with respect to evaluating the evidence. So the colloquy went like this. I explained to the judge, so again, you know, a 90-minute deposition with appropriate safeguards associated with the conduct of a deposition by rule is, I think, as Justice Walker clearly understood, the appropriate way to go. The court responded, and when you say appropriate safeguards, according to the rules, would you agree that questions about Ms. Pratt's family would have no relevance, no materiality? I answered yes, except to the extent of any knowledge of any involvement by them in sign-related activities. I mean, that would go to it. That's what the case was about. The court responded, if she knew about it, if they. I responded, if she knew, exactly. The court said, if she were with them. I said, if she knew or had any right. The court then said, or if they were with her when she was in Maine. I said, if she had any information about that, then I would think that that would be well within the scope of the litigation. And I also pointed out to her on that same page that Justice Walker had specifically offered to be telephonically available to resolve any issues that may arise during the course of depositions in the case, including any perceived harassment that any opponent, including Ms. Pratt or Ms. MADORE, quote, may request to be resolved, unquote. So that, when I read her reason for denying the motion for reconsideration, I knew that it was incorrect. I knew that her memory was not very... And to be perfectly honest, I was really kind of troubled about what kind of level of unbiased treatment I was really getting at that point. There were 3 motions to disqualify that I filed during the course of this 7-year nightmare for me that started just because I was asking, with the support of a Maine court, to take Ms. Pratt's deposition.
But what happened to your 59H motion to dismiss, the anti-SLAPP motion?
Right.
What happened to that?
She denied it outright. I'd have to go back, Your Honor, and look at her reasons for denial. She basically just said she didn't feel it applied. As Your Honor is well aware, there's an awful lot of similarity, in some respects overlap, between anti-SLAPP and abuse of process, as the case law has clearly indicated. As Justice Hodgens has...
You didn't pursue that on appeal, right? The denial of the 59H.
I did not. I stuck with the abuse of process counterclaim, her decision to allow that to basically be reignited and to go forward. And there I was having to defend myself, and defending myself I don't think is process either. I mean, I was pretty bewildered about the whole thing, and it was more than concerning. It was frankly humiliating.
So when Maine issues the letters rogatory, when you come here, could the Massachusetts judge have put any further restrictions on what was to transpire at the deposition, or, and I don't mean to be flip about it, was it simply a rubber stamp to allow the process to issue out of this state?
That's an interesting question. I honestly don't know the answer to that. I suppose she could have done that, and then I would have had to evaluate it and decide what, if anything, to do with it.
No, could she have said, you know what, you're not going to take it at this law office. It's too far for this woman to travel. I'm going to have you take it at this law office.
Sure, and I think I'm pretty sure I indicated her I was happy to do it in Massachusetts. And the opposing counsel in the Maine case had already indicated to me they were willing to drive down. It's not that far, from York County, Maine to Haverhill or Amesbury or wherever, or Newburyport, wherever we would need to do that.
Let me just check with the panel because I do see you're out of time. I think we're going to have to leave it there. Thank you very much.
Thank you very much.
Mr. Gleason.
Good morning.
Good morning.
Judge Hodgens, with regards to the case that you cited, relevant information. One of the things that transpired in this case, and the primary thing that transpired in this case, is in the decisions that were rendered and the hearing that was conducted. When Mr. NADEAU had his opportunity to show that he brought it in good faith when the question was raised, he gave 2 bases for his claim. Number 1, he said that there was testimony from Ms. Lovejoy, who is her son, Ms. Lovejoy is the registrar of probate in the court where Mr. NADEAU had worked. And her son was accused of doing something with signs up in Maine. And that she had given some information that would be relevant, that including that my client had knowledge of what had happened to signs. There was nothing in her testimony at a deposition that had that. Number 2, it was suggested as, again, the basis for the good faith that Mr. Brodeur had testified under oath that Ms. Pratt had done something. It was pure speculation. So at the very outset, it was asserted that there was no good faith because this was coming after Ms. Pratt for a deposition. Everything that he said here is what he was saying at that time. Now, when Ms. Pratt, who was pro se at the time, had the opportunity to speak, she began to give the history of what had happened when dealing with this individual.
Yeah, but you know what? And that troubled me too, because I'm not so sure that history was particularly relevant. We have an individual who's brought a civil action against this Mr. Lovejoy, okay? Now, that litigant has a right to broad discovery to pursue that litigation. Now, if Massachusetts had not been involved, and if it was just up in Maine, there would be no judicial involvement. The discovery would be carried on by the parties in the usual course. But Mr. NADEAU just had the bad luck of having to seek some kind of relief from a Massachusetts judge to go hat in hand and say, may I take this deposition on a Massachusetts resident, which should have been, as I said, a ministerial sort of act of providing, comedy and so forth, C-O-M-I-T-Y.
Yes, yes, as opposed to
Right.
C-O-M-E-D-Y.
And you would think that is in the usual course, and it's probably done with some frequency.
Yep.
But instead, it turned out to be a complete disaster, and it only got worse from that point on. So my point is, if a litigant is entitled to broad discovery in Maine to support the claim that has been filed, why should it be any different if he's seeking some kind of relief in Massachusetts? Isn't he still entitled to that broad discovery?
It did what? I couldn't quite hear.
If he comes down to Massachusetts and asks a judge, may I take this deposition of this Massachusetts resident, he doesn't lose that entitlement to broad discovery, does he?
Well, he doesn't. If we're assuming that, again, that it would be this, in Maine. The fact when he comes to Massachusetts, though, doesn't he have to demonstrate that if he wants an order, that it's in good faith? And that's number one, I would suggest. And he had, so it's a two-prong, because the deponent has the right to respond. And I don't think it's, I think it's crucially important, because what Ms. Pratt was saying is his representations are false. He's not here to take my deposition. I don't know anything about what happened up there. Here's why he's down here looking for me. He got beat in an election, and he's done this to me twice already. In 2010, I had to go through, she had written a book about him, and he was claiming that the allegations and the facts that she suggested were false and defamatory. And she had to go through in 2010 a 2-year litigation that on the eve of trial, Mr. NADEAU had 8 counts, including defamation, etc., in the world, in his lengthy way, and he withdrew all 8 with regards to the issue that he was claiming, which is he had been defamed. She had to pay for and go through 2 years of brutal litigation, because he doesn't litigate in short papers. He said in questioning Ms. MADORE, he brought a short stack of papers to her when she was on the stand and said, isn't this, when you're complaining of your emotional distress, isn't this the paperwork in your case? That's what he did.
Oh, okay.
When I got the opportunity...
Here's the thing, though. I'm not, and let me just say this, because I know there's a long history, and I appreciate everything you're saying, and I'll even go one step further. Just accepting all of that is true, and you make very good points. But my point, it's much narrower. I'm looking at the statute, Chapter 223A, Section 11. A court of this Commonwealth may order a person who is domiciled or is found within this Commonwealth to give his testimony or statement, or to produce documents or other things for use in a proceeding in a tribunal outside this Commonwealth. And it goes on from there. I've read this a number of times. I was trying to read it and listen to you at the same time. I don't see anything in there about good faith. Is there something in there that says you have to demonstrate good faith to get this deposition underway?
No, but what it does say is may.
Correct.
All right, it says may, number one, and then the specific case that, if I heard your reading of Alphas correctly, and I think I did, it says pursuing relevant information, relevant, and
Well, but Rule 26 always talks about relevant information. It may not be admissible. We know that you get a body of discovery,
Right,
and a
right.
slim piece of it is admissible. But to Justice Hodgens' point, once the main judge said, yes, you can take her deposition, but you got to go to Massachusetts and jump through the hoops, hasn't the judge made that preliminary determination that it's relevant in the big picture?
Judge Fahey talked about that. My client wasn't present. If there were what were represented up there are the people who were defendants in the action. Ms.
It's not
Pratt,
unusual, though, even in an in-state discovery situation, third parties don't always know what's going to happen at a deposition, or that they're even the subject of a subpoena. They get noticed of a deposition, their lawyer comes in, maybe they do a motion to quash, right?
right. Exactly. And in this particular case, when
They
he
don't
brought...
do an abuse of process claim, they do a motion to quash.
Pardon me, sir? Ma'am, I'm sorry.
That's all right.
Judge, Your Honor, my apology.
Call me whatever you want. They file a motion to quash, they don't file an abuse of process claim.
But what they do is they object. And what went to another step here, and again, with respect, a 2-year lawsuit where 8 counts are voluntarily withdrawn by the plaintiff, and then immediately thereafter filing a second lawsuit that took 2 years, and then after the jury was impaneled over 4 days, same thing about I've been defamed and everything else. After those 4 days, he brought his own motion to dismiss his own case. And Judge Kottmeyer ruled, I deny your motion to dismiss the case, but I am going to dismiss your case because it is a waste, it is a waste of judicial economy and time.
Can you answer this question? Take away all the facts.
I'm sorry?
Take away all the facts, okay? Because the facts cause everybody's blood pressure apparently to go up a few points, and I don't want to see that happen. Let's take away the facts and answer this question. Can you have a claim for abuse of process when the alleged violation is a discovery violation? Can you support an abusive process when the basis of the claim has to do with a discovery request?
Well, Judge, the answer is yes. When somebody files, now in the ordinary earth here, and somebody sends a request for a notice of deposition, that in and of itself would not be a basis for it. When someone files a lawsuit, the issue becomes the filing of the lawsuit and then what transpires, because when he asked for
But
it,
isn't it the initiation of the civil suit? So that, take a car crash in Massachusetts, and a lawyer goes and just has depositions of everybody who lives on the street, even though the crash happened way down the road. What a waste of time. I was at work that day. I wasn't even there. Okay, so do I have an abusive process?
if it was brought in good faith, absolutely.
Because I still don't understand the good faith. No, there's the initiation of the civil suit. Somebody got hurt and has a bad back now, but I was at work and now I get this deposition. I've got to go to, what a waste of time. I have nothing to offer, and I think the attorney is just doing it to be vexatious. Do I have an abusive process?
Based on that belief, the answer is no. But if the facts support, as they do in this case, because when the issue got raised of did this simple little event, did it happen in good faith? Okay, no. But was it demonstrated that it was far worse than that? It's actually bad faith.
But the process, so that, sure, initiating a suit, you sue somebody, you have absolutely no right to do so. That seems to abusive process to me. You're a little bit too much on the discovery. Isn't that just a sanction, a motion to quash, a penalty that can be meted out?
Well,
Is it a
Judge, all I
whole
could
claim?
say is that when the opportunity to be presented with having a good faith basis, he couldn't come close to meeting that burden. And when Ms. Madore Pratt had suggest that it was bad faith, she raised issues which were overwhelming, demonstrating, I would suggest, bad faith. And what he came here was because he was angry, and Ms. Madore Pratt has always been one of his targets, one of his selected targets, and she didn't pursue anything after the first time when 8 claims of defamation were withdrawn. She didn't make the claim or pursue anything the second time after 2 years, and his case was, he moved to dismiss his own defamation claim. He moved to dismiss it after 2 years. This is the third strike.
Okay, and let me just ask you this one last question from me, because I think this is where it shows your argument falls apart for this reason. Assuming everything you've said is true, that not only is there a lack of good faith, but there's bad faith. Let's just assume that Mr. NADEAU really dislikes this potential deponent, there's bad blood, he has every reason in the world to harass her. It's a terrible thing to do. Assume all that is true. You're still putting the cart before the horse here, because what if that potential deponent had some important evidence to offer? What if she came in to that deposition and said, well, as a matter of fact, I saw Mr. Lovejoy, and he went to 6 different properties, and he removed signs, he slashed signs, he taped signs over signs, he did all this sort of thing, and it makes Mr. NADEAU's claim.
And there's an answer for that.
What is it?
Isn't it the ordinary practice in that kind of a scenario to call somebody on the phone, have an investigator go, talk to the person? Why did you involve the courts? Why are you getting the courts involved? Why isn't that the simple remedy? Isn't that how practice is conducted? You send somebody down, oh, by the way, do you know anything about this? No, I don't. Or, in the alternative, yes, I do. So this wasn't, to make it's your point.
It's not under oath.
That's all true. It's not under oath. But if somebody says something that I don't have any information, that's the answer that you get. And you're stuck with it. And the fact of the matter is, that's not what was done here. Why were the courts used as a vehicle on something so simple? And if we wish to ignore history, then that's not my decision. But history tells us, unless we put a blind eye to it, history is of this man came after this woman for 4 brutal years and then walked from his own claims, and here he comes again, and something as simple as sending somebody, having somebody else, well, I've got bad blood with her. Joe Jones, would you just ask her if she knows something? Harry the sheriff, go ask her if she knows something. And that's how it would be conducted. Not with this man, and when he had every opportunity to demonstrate good faith, he didn't have it, and when she had every opportunity to demonstrate bad faith. So what's the point of having it? Yes, it is, I don't disagree, it's a discovery issue, but the fact of the matter is, he brought it into the court, not Madore Pratt.
Mr. Gleason, we're going to have to leave it there. Thank you.
Thank you. Thank you, Your Honors.
I just want to check with our staff. Normally we would break, but we only have one more case. Are you okay if we don't take a morning recess, Ms. Montgomery? Mr. Spady? Ms. Fisher, you okay? All right, we are going to hear the last case then that's in the courtroom. Hopefully everyone